You're listening to Study for the Bar in your car. I created this podcast because I've been spending a lot of time in my car, but I haven't found many resources for actual bar study in an audio format. So I figured I would create my own podcast for a few reasons. Number one, I want to pass the bar exam. My thinking is that if I can dissect this information in a way for others to understand, that I'll be able to understand it better. But also, I want something to listen to while I'm driving. And this also goes for other forms of travel, whether you're on the airplane, if you're on the tube, if you're on the train, etc. So here's how it works. I've been studying for the bar exam for years and years and years. It feels like I've been studying for it forever. I have lots of notes, my own notes, copious notes. I have my own massive outlines. I have so much material. I think I have too much stuff. Well, I've put all my notes and all my outlines, everything together in a language model. Now, this is AI, more or less. So when I've put all of these things together, the output I've set is a podcast. And what we get is a male and female podcaster talking about the content, going over the study materials in a really fantastic way. In fact, they sound more real than I do now, and they're just bots. So, a few things to mention. What I'm going to do is start off every episode just speaking about some bar stuff that I'm doing, and then we'll have my AI friends join you, and then I'll come back in the end and I'll wrap it all up. So to start off, please remember, I'm a student just like you. I'm not an expert, and I haven't passed a state bar exam yet. Number two, I'm not giving legal advice. I've literally put my own comprehensive notes into AI, and the podcast is the result of that. Number three, AI isn't always correct, so don't come for me if there's an error. If I do find something, I will do my best to correct it. Number four, when you're driving, the most important thing is to be safe on the road. So if this podcast is going to distract you from driving, then you should definitely hit pause. Now, it's taken considerable time and my own resources to put all this together. I'm a poor law clerk, and I'm not asking for a donation, but if you know an attorney that needs a law clerk and that is hiring a law clerk, let them know. So I work as an independent law clerk for attorneys across the country. Extra set of eyes to look over something. Have them call on me. Yes, I am a law clerk. I specialize in deep dive research, writing motions, complaints, and appeals. I do lots of other stuff too. The areas that I really specialize in are personal injury and also criminal law, but I will do all sorts of stuff. I used to be a judicial law clerk, and I have a love of writing. Essentially, I'm a ghostwriter for attorneys. So if you are an attorney and you need help, or if you know an attorney who needs help, have them contact me at hello@legalwriterandlawclerk.com. That's hello@legalwriterandlawclerk.com. Now, if you want to contact me about this podcast, you can contact me at podcast@studyforthebarinyourcar.com. You know what? I really love long URLs, apparently. Anyhow, here it is. We're kicking things off with my AI friends with civil procedure. Let's get into it.
Welcome to this deep dive, your Study for the Bar in Your Car companion.
Great to be jumping into this.
Today we're laser focused on, well, a really foundational area for bar success, civil procedure.
Absolutely critical. You can't pass without knowing this stuff.
And a huge thank you is in order for Angela, an LLM law student, for compiling the fantastic materials we'll use today.
Yeah, we're calling them Angela's notes, and they are super helpful.
Definitely. So our mission here is, a clear, efficient overview of the key Civ Pro concepts.
Hit the need-to-know areas, keep you on track.
Exactly, without getting totally bogged down. Think of it like a roadmap.
Covering the whole journey, really, from where a case starts.
Right through to the final appeal. We'll pull out those core principles you absolutely need for your bar prep toolkit.
Sounds good. Civ Pro is basically the rule book for federal lawsuits, right?
Yeah, right.
Understanding it isn't just about memorizing rules, it's knowing the strategy, the potential traps, as a case winds its way through the system. Angela's notes give us a great framework.
Yeah, hitting jurisdiction, venue, what law applies.
Pretrial, trial, appeals,
Mhm.
all the essentials. Let's get started.
Okay, let's dive right into that very first question when a legal problem pops up. Where can you actually file the lawsuit?
Yeah, where do you begin?
And Angela's notes remind us this boils down to two key things. First, personal jurisdiction.
Does the court have power over the actual people or companies involved?
Right. And second, subject matter jurisdiction.
Does the court have the authority to even hear this type of case?
Let's tackle personal jurisdiction first.
Okay. The big idea here, as Angela's notes really stress, is minimum contacts.
Minimum contacts.
Yeah. For a court to fairly pull a defendant into its state, that defendant needs, well, enough connection with that state.
This is not just random.
Exactly. Did the defendant purposefully reach out, like do business there, target residents? Angela's notes call it purposeful availment.
Purposeful availment.
And it shows intentional engagement, making it, reasonable for the state court to step in.
Got it. And Angela's notes point out a kind of interesting edge case, too.
Mm.
Even just being physically present in the state for a short time can be enough for personal jurisdiction.
If you're served properly while you're there, yeah, tag jurisdiction.
Right, tag jurisdiction. Unless, of course, you were tricked or forced into the state just to get served.
Yeah, that's a narrow exception, but definitely something to flag for the exam.
So there's one specific way. What are the broader categories?
Well, more commonly, you have specific jurisdiction. This is when the lawsuit itself directly connects to the defendant's activities in that state.
So the claim arises from the contacts.
Precisely. Angela's notes say even a single contact might be enough if the lawsuit stems right from it.
Okay.
Then you've got general jurisdiction. This is much broader. It's when the defendant is essentially at home in the state.
At home, so that you can be sued there for pretty much anything.
Pretty much anything, yeah. Even if the lawsuit has nothing to do with their activities in that specific state. For corporations, Angela's notes highlight, this usually means their state of incorporation.
Where they filed the papers to become a corporation.
Right. And their principal place of business.
Where the main operations are, the headquarters.
Exactly, where the big decisions get made. Knowing that distinction specific versus general is really crucial.
And Angela's notes bring up a practical point for the bar exam, too.
Yeah.
A defendant can actually lose their right to object to personal jurisdiction if they don't raise it right away.
Yeah, that first response, the answer or a motion, is critical for that defense. You waive it if you don't raise it then.
But subject matter jurisdiction, that's different.
Totally different. That can be challenged anytime by anyone, even the court itself. It's about the court's fundamental power.
Okay. And federal courts usually just follow the state's rules on personal jurisdiction.
Generally, yes. With a few wrinkles, like the bulge rule Angela's notes mentioned.
Right, that 100-mile bulge for joining certain parties later on.
Yeah, allows service just outside the state lines in specific joinder situations.
It seems like these rules are trying to balance fairness.
Yes. Fair to defendants, not dragging them into court somewhere they have no connection to, but also fair to plaintiffs, giving them a place to seek justice.
And Angela's notes mentioned quasi and rem jurisdiction, too.
Yeah.
Based on property.
Yeah, it's based on property the defendant owns in the state. Less common now because the Supreme Court has said you still need those minimum contacts, a reasonable link between the defendant, the property, and the lawsuit. You can't just seize property unrelated to the claim to get jurisdiction anymore.
Okay, so that covers where someone can be sued. Now, how do you actually, officially tell them they're being sued?
Service of process. Crucial step.
Angela's notes really stress this. Proper service is non-negotiable.
Absolutely. Even if the defendant knows all about the lawsuit, maybe read it in the news. If they weren't served according to the rules, any judgment later on could be void. Invalid.
Wow. Okay, so what's the timeline like?
Typically, Angela's notes outline, once you're formally served, you've got 21 days to respond. Answer or file a motion.
21 days. That's not long.
It's not. But there's an incentive to cooperate. If the defendant agrees to waive formal service, basically says, okay, you don't need the sheriff to hand me the papers, they get longer.
How much longer?
Usually 60 days to respond, or even 90 if they're outside the U.S. Saves time and hassle for everyone.
And Angela's notes mentioned a deadline for the plaintiff, too, to actually serve the defendant.
Right. You generally have 90 days after filing the complaint to serve the defendant. Miss that deadline without a good reason, and the court might dismiss the case.
Okay. And how can you serve someone? Are there options?
Yes. Angela's notes point out you generally have flexibility. You can usually follow the state law rules for service in the state where the federal court is located,
Or
or the rules of the state where service is actually being made. Gives you options depending on where the defendant is.
All right, so jurisdiction and service are sorted. Now, within the federal system, which specific courthouse is the right one, that's venue, right?
Yeah, exactly. Venue is about the proper district within a state or system that already has jurisdiction. It's more about geography and convenience.
So how do you figure that out? Angela's notes lay out the main options.
Yeah, generally, venue is proper in a district where any defendant resides if all defendants reside in the same state.
Okay, what if they live in different states?
Then you look at where a substantial part of the events giving rise to the claim occurred. That's often a key location.
Makes sense.
Or, kind of as a fallback if the other two don't work, venue might be proper where any defendant is subject to personal jurisdiction.
So those are the main places you can file.
Those are your main options, yeah. Venue is really about finding a sensible location within the system.
And Angela's notes mention you can sometimes move the case even if the first place was technically okay. Transfer a venue.
Right. Even if venue is proper where you filed, the court can transfer it to another federal district where the case could have been brought originally.
Why would they do that?
For the convenience of the parties and witnesses, or just generally in the interests of justice. If another location makes way more sense for everyone.
But the new place has to be one where the case could have started.
Absolutely. That's a key point from Angela's notes. The transferee district must have proper personal jurisdiction over the defendants and be a place where venue would have been proper initially. You can't just transfer it anywhere.
Okay. Angela's notes also mention something called forum nonconvenience.
Yeah, that's a bit different. It's not transferring, it's dismissing the case.
Dismissing, even if jurisdiction and venue are okay.
Yes, in rare situations. The idea is that there's another court system, maybe in another country, that is so much more convenient and appropriate that the current court should just dismiss the case and let it be filed there.
But Angela's notes say this is rare, especially if the plaintiff lives in the current forum.
Very rare, especially then. Courts give a lot of weight to the plaintiff's choice of forum, particularly if it's their home turf.
Got it. And one last thing on venue from Angela's notes. Contracts. Forum selection clauses.
Right. If the parties agreed in a contract beforehand where any disputes would be litigated, federal courts generally enforce those clauses. They take that agreement seriously.
Okay, that makes sense. Let's shift gears now. Huge question in federal court. What law do they actually apply?
Crucial question. This brings us to the Erie Doctrine, which Angela's notes rightly emphasize. This is super important for the bar, especially in diversity cases.
Diversity cases meaning parties from different states, and the amount in controversy is over $75,000.
Exactly. That's the classic scenario where Erie comes up.
So break down Erie for us based on Angela's notes. What's the general rule?
The general rule in diversity cases is federal courts apply state substantive law.
The law that defines rights and duties, like contract elements or negligence.
Precisely. And federal procedural law.
Like the federal rules of civil procedure, rules of evidence,
Um,
the how-to of running the case in federal court.
Exactly. State substance, federal procedure. That's the starting point.
But Angela's notes flag an important exception, right? What if there's a conflict?
Ah, yes. If a valid federal procedural rule, like one of the federal rules of civil procedure, directly conflicts with a state law, even a state procedural law,
Then what?
the federal rule generally wins in federal court. As long as the federal rule is valid under the Constitution and the Rules Enabling Act, federal procedure usually trumps in federal court when there's a direct clash.
Okay. And what if there just isn't a federal rule on point? Angela's notes mention this too.
Right. If federal law is silent on a particular issue, the federal court has a choice. Sometimes they might create a uniform federal common law rule, but more often, especially on substantive-ish issues, they'll adopt the state law rule to fill the gap. It depends on the context.
And if they do apply state substantive law, how do they decide which state's law, if maybe multiple states are involved?
Good question. Angela's notes point out that the federal court uses the choice of law rules of the state in which it sits.
So the federal court in, say, California would use California's rules for deciding whether California law or maybe Nevada law applies to the substance of the dispute.
Exactly. It borrows the home state's choice of law rules.
Okay. And one more piece from Angela's notes on this.
Yeah.
Respecting state court decisions. Full faith and credit.
Yes, crucial for preventing endless litigation. Federal courts must give state court judgments the same preclusive effect, meaning whether it prevents relitigating the same claim or specific issues.
Claim preclusion and issue preclusion.
Right. They have to give it the same effect it would have in the courts of the state that originally issued the judgment. Respect for state court decisions.
All right, so we've laid the foundation. Where to sue, what law applies. Now let's get into the actual process before trial. The pretrial procedures, Angela's notes cover a lot here.
Yeah, this is where a lot of the action happens in civil litigation. It starts with the pleadings.
The initial documents, the complaint.
Exactly. The plaintiff files the complaint to kick things off, and Angela's notes highlight the three essential parts.
Okay, what are they?
First, a statement showing the court has subject matter jurisdiction. Got to establish that power.
Right. Second.
Second, a short and plain statement of the claim showing the plaintiff is entitled to relief. This is notice pleading.
Just enough to let the defendant know what the lawsuit is about.
Basically, yeah. And third, a demand for the relief sought. What does the plaintiff want the court to do? Money, injunction, etc.
Okay, complaint filed. Then the defendant responds with an answer.
Right. And in the answer, Angela's notes explain, the defendant goes through the complaint's allegations. They can admit them, deny them, or say they lack sufficient information.
But Angela's notes had a warning about denials.
Yeah, be careful with just denying everything generally if you know some parts are true. That can violate Rule 11.
Rule 11, the ethical rule.
Right, requiring good faith and reasonable inquiry. A bad denial could lead to sanctions on the lawyer, the firm, maybe even the client.
Yikes. Okay. Can pleadings be changed later? Amended.
Oh, yeah. Angela's notes cover this. You usually get one amendment as of right early on without asking the court.
Again later.
Later, you usually need the court's permission, but Angela's notes stress that courts are generally supposed to freely give leave when justice so requires. They're pretty liberal about allowing amendments.
And sometimes those amendments can relate back. What does that mean?
It means the amended pleading is treated as if it were filed on the date of the original pleading. This is huge for statute of limitations issues.
Okay. Especially if you need to change or add a party after the deadline.
Exactly. There are specific rules for when changing a party relates back, usually involving whether the new party knew or should have known about the suit. Very important detail from Angela's notes.
Okay. And Angela's notes also mention Rule 11, again, more broadly.
Yeah, it applies to basically all court filings, pleadings, motions, etc. Signing a paper certifies you've done your homework. Meaning, it's not for an improper purpose. The legal arguments have merit. The factual claims have support, or likely will after discovery. It's about responsible lawyering.
Got it. Now, who can actually be in the lawsuit? Joinder rules, right? Angela's notes cover these.
Right. How you bring parties and claims together. First, permissive joinder.
Letting people join forces.
Yeah. Multiple plaintiffs can sue together or be sued as multiple defendants if their claims arise from the same transaction or occurrence.
Same basic event.
And share a common question of law or fact. It's about efficiency.
Makes sense. But Angela's notes also mention compulsory joinder, Rule 19.
Yes, this is where the court requires a party to be joined if they're considered necessary or required.
Necessary how?
If the court can't provide complete relief without them, or if their absence would prejudice them or the existing parties.
And if you can't join them, maybe it messes up diversity jurisdiction.
That's a classic problem Angela's notes illustrate. If a required party can't be joined, maybe due to jurisdiction issues, and the court decides they're truly indispensable, the whole case might have to be dismissed. It shows how these rules interact.
Wow. Okay, what other kinds of joining are there?
Yeah.
Angela's notes mentioned cross-claims.
Right. That's a claim by one party against a co-party, like one defendant suing another defendant in the same case.
As long as it's related to the original lawsuit.
Exactly. Must arise from the same transaction or occurrence.
And counterclaims.
That's the defendant suing the plaintiff back. Angela's notes distinguish between permissive counterclaims, unrelated, can be brought, and compulsory ones.
Compulsory means?
Means if the counterclaim arises from the same transaction or occurrence as the plaintiff's claim, the defendant must assert it in this lawsuit, or they lose the chance to bring it later. Use it or lose it.
Okay, use it or lose it.
Okay.
Then there's impleader, third-party practice.
Yeah, Angela's notes explain this. Lets a defendant bring in a new party, a third-party defendant, because the defendant thinks this new party might be liable to them for all or part of whatever the plaintiff might recover from the defendant. Passing the buck, essentially.
Like, if I'm liable to the plaintiff, it's really this third party's fault, and they should pay me back.
That's the idea. And finally, intervention.
Outsiders wanting in.
Pretty much. Non-parties who want to join an ongoing lawsuit. Angela's notes say they might have a right to intervene if they have an interest that could be harmed by the case outcome.
Or-
Or they might get permissive intervention if the court allows it, usually because their claim or defense shares a common question with the main action.
Lots of ways to get parties involved. What about class actions? Angela's notes touched on those.
Right, where one person or a few people sue on behalf of a whole large group. Angela's notes make the key point that federal procedural rules for class actions govern in federal court, even if state law is different.
And you need court certification for that.
Absolutely. You have to meet specific requirements noted by Angela: numerosity, too many people to join individually; commonality, shared questions; typicality, representatives' claims are typical; and adequate representation. Reps and lawyers will protect the class.
And different types exist.
Yes, with different rules about notice and whether class members can opt out, as Angela's notes mention. Complex area.
Okay, moving into discovery. The information gathering phase. Angela's notes say this doesn't start right away.
Correct. Formal discovery generally waits until after the parties have their Rule 26F conference. They meet, discuss the case, and develop a discovery plan.
And they have to share some info automatically. Initial disclosures.
Yes, Angela's notes highlight this. Parties have to provide certain core information like relevant witnesses and documents early on without even waiting for a request. Promotes transparency.
So what are the main tools for digging deeper, according to Angela's notes? Interrogatory.
Yep, written questions sent to another party. They have to answer in writing under oath after reasonable investigation.
Can you object if they're too much?
Sure, you can seek a protective order if they're unduly burdensome or seek privileged info.
Okay. Then request for production.
Right, that's how you get documents, emails, ESI electronically stored information, tangible things from another party. Angela's notes say you need to describe what you want with reasonable particularity.
Makes sense. Depositions.
Those are the oral question and answer sessions under oath, usually in a lawyer's office with a court reporter typing everything down. Angela's notes mention limits on how many and how long without court permission.
And request for admission.
Those ask the other party to admit the truth of certain facts or the genuineness of documents. Angela's notes point out if you don't respond within 30 days, the matters are usually deemed admitted.
And if you deny something unreasonably.
And the other side later proves it true. Angela's notes warn you might have to pay their costs for proving it, encourages reasonable admissions.
Okay. Is anything off limits in discovery?
No.
Work product.
Generally, yes. Angela's notes explain that work product materials prepared in anticipation of litigation by or for a party or their representative, like a lawyer, is protected.
Unless
the other side shows substantial need for the materials and that they can't get the equivalent information otherwise without undue hardship. Even then, the lawyer's mental impressions and strategies usually stay protected.
And if parties don't play fair in discovery.
Sanctions. Angela's notes remind us courts can penalize parties for failing to respond, hiding evidence, or violating discovery orders.
Okay. What about pretrial conferences? Angela's notes mentioned those.
Yeah, Rule 16 conferences. The scheduling conference early on sets deadlines for joinder, motions, discovery completion, keeps the case moving.
And later ones.
Later pretrial conferences focus on streamlining the trial, exploring settlement. Angela's notes stress the final pretrial order is key. It basically controls the course of the trial, superseding the pleadings on the issues to be tried.
And quickly, Angela's notes mentioned emergency relief, TROs, and preliminary injunctions.
Right. Used to prevent irreparable harm before trial. TROs, temporary restraining orders, are very short-term, sometimes even without notice in emergencies. Preliminary injunctions require notice and a hearing, and last longer, pending the trial outcome. Angela's notes say there are specific legal standards you have to meet for both.
Okay, deep breath. We've navigated pretrial. What if the case actually goes to trial? Jury trials.
Angela's notes remind us the Seventh Amendment gives a right to a jury trial in federal court for suits at law, usually meaning cases seeking money damages.
So it depends on the remedy sought.
Exactly. Legal remedies get a jury right. Equitable remedies, like injunctions, generally don't. If you have both legal and equitable claims mixed together with common facts,
What happens then?
usually the jury decides the facts for the legal claim first, and the judge is then bound by those findings when deciding the equitable claim.
How do you ask for a jury? Angela's notes mention a deadline.
Yes, a written demand is needed, typically within 14 days after the last pleading directed to the issue is served. Miss it, and you waive the right.
Okay. And picking the jury? Voir dire.
Right. Lawyers question potential jurors. They can make challenges for cause arguing a juror is biased or unqualified.
And peremptory challenges.
Those let you strike a limited number of jurors without stating a reason. But big caveat from Angela's notes, you can't use them to discriminate based on race or gender. That's the Batson rule.
Got it. How big is a federal jury, Angela's notes say?
At least 6 members, no more than 12. And unless the parties agree otherwise, the verdict must be unanimous and returned by at least 6 jurors.
Unanimous. And you can poll them.
Yeah, ask each juror individually in open court if that's their verdict.
What about the judge's instructions to the jury? Angela's notes had a point about objections.
Crucial point for appeals. If you disagree with a proposed jury instruction, you must object on the record, stating your specific reason before the jury retires to deliberate.
If you don't?
You generally waive that objection for appeal unless it was a plain error affecting substantial rights. Very hard standard to meet. Objecting properly is key.
Okay. Let's talk motions. Lots of different types. Angela's notes cover pretrial motions first.
Right. Before trial, you might see motions to dismiss for lack of jurisdiction, improper venue, failure to state a claim.
The 12B motions.
Exactly. Angela's notes interestingly point out you can file a motion to dismiss for bad service even after you filed one for failure to state a claim. Sequence matters.
What else before trial?
Motion for judgment on the pleadings, after pleadings close. Motion to strike irrelevant stuff from pleadings.
And the big one, summary judgment.
The big one, indeed. Angela's notes explain this, asks the court to rule before trial because there's no genuine dispute about any material fact and the moving party deserves judgment legally.
No real fight about important facts.
Right. The court looks at the evidence affidavits, deposition excerpts, etc. in the light most favorable to the non-moving party.
And the non-moving party has to fight back with evidence.
Yes, crucially. Angela's notes stress you can't just rest on your pleadings. You need to show specific facts demonstrating a genuine issue for trial.
Can the judge grant it if witness credibility is key?
Generally, no. Summary judgment isn't for weighing credibility. That's for the trial.
And if your summary judgment motion is denied, can you appeal right away?
Usually, no. Angela's notes confirm denial of summary judgment is typically not immediately appealable. You usually wait for the final judgment after trial.
Okay. What about motions during trial? Angela's notes mention JMO.
Judgment as a matter of law used to be called directed verdict. A party moves for this, usually after the other side finishes presenting their evidence.
Arguing what?
Arguing that even looking at the evidence in the light most favorable to the non-moving party, no reasonable jury could possibly find for them. There's just not legally sufficient evidence.
And Angela's notes had a key point about doing this before the verdict.
Absolutely critical. You must move for JMAL at the close of all evidence, or sometime after the opponent rests, to preserve your right to make a renewed motion for JMAL or JMOL after the verdict comes back if you don't like it.
So making the first JMOL is a prerequisite for the post-verdict RJML.
Exactly. It's a procedural gatekeeper noted in Angela's notes.
Okay. And verdicts themselves. Angela's notes mentioned types.
Yeah, general verdict is simple. Fines for plaintiff or defendant, maybe states damages. Special verdict has the jury answer specific factual questions, and the judge applies the law to those findings.
Got it. Now, judgments. The final decisions. Default judgment.
Angela's notes cover this. It's when a defendant just doesn't show up or respond at all. The court can enter judgment against them.
Any notice needed if they appeared initially but then defaulted?
Yes, if they've appeared in any way, they generally get at least 7 days notice before the default judgment hearing.
Okay. We covered summary judgment and JMOL or JMOL. What about a motion for a new trial? Angela's notes mention that.
Right. Filed after the verdict, asks the judge to basically order a do-over.
No grounds.
Could be legal errors during trial, newly discovered evidence, prejudicial misconduct by the other side, or if the judge thinks the verdict is just clearly against the great weight of the evidence. Angela's notes say it's often filed alongside an RJML motion.
And there's a strict deadline for these post-trial motions.
Very strict. Angela's notes emphasize 28 days after the entry of judgment for RJMOL, new trial motions, motions to amend the judgment. No extensions generally allowed for that deadline.
Wow, 28 days. Okay, what if you need relief from a judgment way later? Rule 60.
Yes, Angela's notes cover Rule 60. It allows relief from a final judgment under specific, limited circumstances.
Like?
Clerical errors anytime. Things like fraud or newly discovered evidence, usually within 1 year. If the judgment is void, reasonable time, or other extraordinary reasons justifying relief, reasonable time. It's not easy to get, but it's there for exceptional cases.
And finally on this, voluntary dismissal, plaintiff dropping the case.
Right. Angela's notes say a plaintiff can usually dismiss voluntarily without court order early on, before the defendant answers or moves for summary judgment.
So there's a catch.
Yes, the two-dismissal rule. The first voluntary dismissal is usually without prejudice, Kenner file, but Angela's notes warn a second voluntary dismissal of the same claim is typically with prejudice, meaning you can't bring that claim ever again.
Okay, last major area from Angela's notes. Appeals. Getting a higher court to review. What's the main rule?
The main rule, the bedrock principle Angela points out, is the final judgment rule. Meaning you generally can only appeal after the district court has issued a final judgment that resolves all claims involving all parties. No appealing every little ruling along the way.
Promotes efficiency, avoids piecemeal appeals.
Exactly. But there are exceptions, right? Interlocutory appeals.
Yes, Angela's notes explain these allow appeals of certain non-final orders in specific situations.
Like what? Orders about injunctions, granting or denying. Orders certifying or denying class action status. Also, the collateral order doctrine for certain important issues separate from the merits.
But Angela's notes specifically said denying a motion to dismiss for lack of personal jurisdiction usually isn't immediately appealable.
Correct. That's typically something you have to wait until after the final judgment to appeal.
Can the district court help get an issue appealed early? Certify it.
Sometimes. Angela's notes mention the district court can certify an order for interlocutory appeal if it involves a controlling question of law where there's substantial disagreement, and an immediate appeal might speed up the whole case. Requires appellate court permission, too.
Okay. And when an appeal does happen, how does the appellate court review things? Different standards.
Yes. The standard of review is key, as Angela's notes detail. Questions of law.
Review de novo. Fresh look. No deference to the trial judge's legal conclusion.
Right. Findings of fact made by a judge in a bench trial.
Reviewed for clear error. The appellate court has to be firmly convinced a mistake was made. Deferential.
Rulings on evidence, admissibility.
Abuse of discretion. Was the trial judge's decision unreasonable? Also deferential.
What about punitive damages constitutionality?
That gets de novo review, Angela's notes say. Less deference there.
And reviewing a jury verdict, like after an R.J. Moel denial.
Substantial evidence standard. Is there enough evidence that a reasonable jury could have reached that verdict? Deferential to the jury.
And those jury instructions where no objection was made at trial.
Plain error review. Super high bar. Error has to be obvious, affect substantial rights, and seriously undermine the fairness of the trial. It's why timely objections are so important. We have definitely covered a ton of ground here in this civil procedure deep dive.
We really have. All thanks to Angela's excellent notes guiding us.
Absolutely. And remember, as you're studying, maybe listening in your car, the key for the bar isn't just knowing the rules in isolation.
Right. It's understanding how they fit together, how they apply in different situations. That's what the exam tests.
We really hope this overview has given you a clearer roadmap, a better handle on Civ Pro, highlighting those critical areas from Angela's notes for your ongoing studies.
Yeah. Keep asking those core questions as you do practice problems. Jurisdiction, venue, what law, what procedural step now, was the trial fair, is this appealable?
Thinking like a lawyer navigating the system.
Exactly, that's the skill.
And remember, each topic we touched on today has more depth, more nuances. It's definitely worth continuing to explore them in your own study time using resources like Angela's notes.
Absolutely. Keep digging deep.
We wish you all the very best as you continue on your bar exam journey. Keep working hard, keep reviewing, and you will be well prepared to succeed.
Okay, hey, it's me again, Angela, your real life living and breathing host. So yeah, that was a pretty comprehensive opening for civil procedure. So we have coming up 8 more episodes on civil procedure where we break it down subject by subject here. And yeah, I think I enjoyed that podcast. I think it's really good to have these 2 people discuss my notes. It's I don't know, it's weird, but I love it. Anyhow, thank you for listening. Please subscribe to this podcast. If you need to reach me about the podcast, you can reach me at studyinthebarinyourcar.com. Thanks so much, and I'll see you on the next podcast.